Hi everyone. After our short discussion of the history of human rights, we'll be spending the next few weeks talking about human rights as international law. And obviously, we have already in the last video, in the last clips, touched upon some of the specific characteristics that human rights as an area of law has, and which also accounts for it coming about relatively late, in particular post-1945, as a specific area of international law. So this is what I will be doing in the following 3 clips. In this first one, I will give you a general overview over particularly the commonalities, but also some of the very general differences between human rights law specifically and the overarching category of public international law more generally. This obviously also answers in part the first reading question. In the second video, I'll zoom in on the question of treaty reservations, something that the chapter by Frédéric Mégret also discusses quite at length. And then in the third video, I will be talking about the horizontal effect in international human rights law. Now, as you have learned from the chapter, human rights law is a branch or a domain of public international law, but one with, as Mégret puts it, specific characteristics. And as such, it's useful to think about the commonalities and the differences when we discuss what exactly this special character, this special nature is. Let's start with the commonalities. And the most important, the crucial one, which is actually the main reason why we consider human rights as a part of international law, is because it is based on the principle of state voluntarism or state consent. Without states specifically agreeing to legal obligations, to having duties, there's also no corresponding right for individuals to invoke. And that we are faced with the regular consent-based system of international law actually has a number of logical consequences. The first and most obvious one is that, just like in other areas of international law, we have to have recourse on legal sources. And as you know, more specifically, this includes treaties, which particularly in the domain of international human rights law are really very crucial. Rights and obligations are put down in conventions habitually, and we'll be spending the next weeks talking about those. There is, however, also customary international law, rights that have risen to the level of custom, and obviously many of the rights that are actually laid down in the Universal Declaration of Human Rights qualify as such. And finally, we have general principles of international law, and things such as the equality of arms in a legal trial, which qualifies as a human right, will also qualify as a general principle of international law in international legal court proceedings. Given that we are working with sources, and especially and particularly often with treaties, it is also not surprising that the regular rules of treaty interpretation apply. So we have to look when we want to know and what exactly a legal obligation in a treaty entails. We need to look at the wording, the objective meaning, ordinary meaning of the words in a treaty provision. We need to look at the context in which it was created, so at the travaux préparatoires and other kinds of minutes from the negotiations of the treaty. And finally, we can look at the object and purpose of a treaty in order to understand how a particular provision should be understood. And it is here that some courts, in particular the European Court of Human Rights, but also the Inter-American Court of Human Rights, have often used this tool to create expansive readings of particular provisions, and we'll be talking about these kind of teleological interpretations of treaty norms in the weeks to come. Another commonality between international human rights law and public international law, and that may be obvious once again, but is the binding nature of legal obligations, so the legal effect that consenting to obligations has on states. Once you have agreed to obligations, you cannot go back on them. Pacta, sunt, servanda. Treaties must be obeyed. And this, as you know, is one of the foundational principles of public international law. So to say, the other side of the coin, the flip side of the principle of state consent. And finally, another commonality is that in international human rights law, we also have to consider state responsibility. So the state is responsible for its conduct, as well as the conduct of its officers, its agents, those working on behalf of the state. However, there are also circumstances that preclude wrongfulness where responsibility actually is not there. For example, there can be unforeseen circumstances, or there can be instances in which a certain type of action is necessary. But here we are already moving to the ways in which international human rights law very specifically and perhaps more concretely deals with such instances through the notion of limitations and derogations. Now, there are obviously also quite a few differences. And actually, in the next 2 videos, I'll be talking about 2 specific differences, namely how reservations operate, and also basically the horizontal effect, and also talk a little bit more about the centrality of the individual. And this is perhaps also something to be already mentioned here. International human rights law is, despite being state-based and consent-based, not really a reciprocal system. So whereas you usually can think of international law obligations as sort of contractual obligations where state A and state B agree to a certain conduct on the basis of reciprocity, really when it comes to international human rights law, we put the individual at the center, and it's the individual who can invoke these rights. This obviously is a sea change, and not only that, it also puts upside down to some extent the logic of the operation of international law, which is the reason why there are other differences that we need to discuss. One very obvious one, and I will leave it at this for this video, is that individuals have the right to petition international courts, quasi-judicial bodies, and so on. It's not states who bring the case, although that is an option, and the chapter does talk about interstate complaint mechanisms, and we will also be covering this in the weeks to come. But the idea is really that if an individual is the one holding rights, then he or she will also have the opportunity to bring the case, to claim their rights, invoke their rights, and eventually get a remedy. This concludes the first video. I now move on to discuss reservations.